Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. So I had an interesting question come to me this week that I thought this would be a good topic to talk about. And it was a divorce listing. And the question came up of who needs to sign paperwork. Obviously, divorce is probably a unique situation where the owners are not always on good terms, don't always want to help each other out. But you could have other situations. You could have an inherited property. You could have an investment property with multiple owners. But it brings some important things to light, and that is understanding who is an owner on record and why that's important. So you need to know, because that's who needs to sign paperwork, right? Not just the paperwork at the end, but the question comes up sometimes, what about a listing agreement? And in divorce, it becomes particularly tricky because the judge, the divorce decree could say, hey, one party gets control of a property, has the right to sell the property perhaps, but there are two people on title. And so how does that work? Well, a divorce decree does not affect the title unless it says, somebody will have to quiet title it over or quit claim deed it over. So it does not affect the title. And so you still have two owners of record. That spouse that's not a part of the transaction, maybe isn't making the decision, still has to sign at the end. And so you don't want to wait till the end, and you really don't even want to list it without having both signatures, unless the court has given power of attorney to one party or another. So you got to kind of look at that divorce decree, maybe have their attorney chime in to let you know who has control and what hoops need to be jumped through. But very important that you don't just assume, well, the court said one party gets to live in it or sell it or do what they want with it, so that overrides the deed, and the other spouse has no rights. Not their name is still on there, their signature is still needed, and technically to list it, you're listing only one party's interest if you only have one party sign. So be aware of that. Make sure, work with the divorce attorneys to get it all clear, who needs to sign what paperwork. If you need to go back to the court because one party won't cooperate, that may be what you ultimately have to do to get the transaction done. Better to know this stuff before you start to list it and run into problems with addenda not getting signed, with getting to settlement and realizing you need the estranged spouse there, and you don't have that person there and can't track them down, and then suddenly your seller's missing, one of the sellers is missing deadlines and breaching contracts, and it turns into a mess. So know before you jump in and start to list that. Work with the divorce attorneys to be clear on who needs to sign what, and and anticipate problems. If you don't have, if you anticipate someone won't sign and you think that's going to be a problem, then work with the divorce attorney who can work with the court to see what needs to be done, if there needs to be power of attorney or a court order to require someone to cooperate, something like that. So yeah, they can be done. They can be done successfully. It's a problematic time of life, but people need help getting through it, and you can certainly be that help. But and part of that help you can provide is anticipating problems beforehand. So go out there, have a great 2020, by the way. If you have comments, topics you'd love to see us cover in 2020, throw a comment to us. Check out our other videos. They're all on YouTube. There's a link below or above. I can't remember where this is going to be posted or where the comments are. But one of those places, we'll cover it. Thanks for chiming in, tuning in.